Okay, so thank you. Looking forward to starting today. I'm now recording. And guys, welcome back. Just administrative stuff for 1 minute before I launch into things. I am very interested in people's feedback. As you can see from this week, we've started to have other people do these types of talks. The goal is really to engage a large network of people so that it's not just the monotone of my voice that you're hearing every single day, but rather professionals in their field who have proven themselves and understand their subject matters. David Feld did an excellent talk yesterday. I'm very grateful for that. We're certainly going to have David do some more in the future, and we're going to have some paralegals do some talks on landlord-tenant. We're going to really try to get down to the crux and answer the questions really almost twice a week, once or twice a week as we can, to keep this current, to keep this active, and make sure that everyone is getting the most out of this channel. And certainly I appreciate everyone's participation actively in this. It matters to me. It keeps me energized as we keep going through this. So with your permission, I'm just going to share a screen now. Let me find screen. There it is. There's my screen. I'm going to share that. Can someone just chat with me and let me know that you are now seeing my screen? I just want to make sure that that's the case. Anyone? You guys are seeing it? You must have your chat. Hold on a second. Oh, there we go. And yes, okay, you're seeing it. Fantastic. All right, so let's please talk about these two facets, family trust and asset freeze. So the first question you may ask is, why in the devil are we talking about this? I've never heard about this. I've been practicing real estate for 10 years. And I've made a lot of money, and I do very well. What are you yammering on about here? And the answer is that this necessarily doesn't really assist you in the sale of your real estate. After all, you're selling a product, and then people largely choose how they're going to take title at their lawyer's office or with their accountant or planners. But it is worthwhile explaining to you some of the tricks that I guess the 1% use when it comes to assets generally, of which real estate is one, and how you can avoid or plan to minimize, I shouldn't say avoid, but plan to minimize your tax as you go forward. So I'm going to start with the family trust, and then I'm going to move to an asset freeze, and then I will open it up for questions and we can have a discussion. So what's a trust? Well, a trust in its simplest form is someone who owns or holds property for someone else. So the owner of a property does not necessarily need to have their name on title. I am able to put down that I am holding property for someone else, and all of the benefits and obligations of my ownership will transfer to that person. This is often done, and you probably have encountered this in your real estate career, in the context of someone who doesn't actually qualify for a mortgage. That's called a bare trust, where someone, let's say a person who is just a student, is buying a condo, and as a result, they want their parents to actually be on title, but their parents don't want to be on title. After all, if their daughter owns this as opposed to them, they will, in fact, be hit with tax. Sorry, the daughter will be tax-free because it will be your principal residence. Mom and dad already have a house, and yet the bank doesn't care about the daughter because the daughter has no credit record and has no income. So the bank is saying to the parents, you go on title. And the parents are saying, from the perspective of tax and true ownership, we don't want to go on title. We'll go on title, but we don't want to go on title. We want our daughter to actually own the property, because if she owns the property, when she sells it at a profit, she can claim her principal residence exemption. So what the parents are doing by putting their title down, by their name on title, is effectively establishing a trust. That's an informal trust. There are also formal trusts. A trust, a formal trust, is a tax reporting entity similar to a corporation that can own property, shares, real estate, whatever it may be. And it is similar to the bare trust that I just talked about with the parents and the daughter, is controlled by an individual for another person. It consists of a bunch of different people. The settlor, I could talk about who that is and how it works. The trustee, the person who's in charge of the assets. The beneficiary, the people who reap the rewards. And the technicalities of how that works are very interesting, I am sure, to law students. But from your perspective, what you care about is that an actual physical document, if you're establishing a tax reporting entity, an actual physical document is created usually by a lawyer or an accountant, but generally by a lawyer, which basically stipulates that any holdings of the trust are for a period of up to 21 years for the benefit of another party. So I'll pause for questions in a second. So let's take the example that I'm going to use here. So Junior is 3 years old. And though she's now toilet trained, you feel that she's less than capable of responsibly monitoring her short position on the Nikkei index. Probably a good assumption. So how do you do it? How do you invest for Junior? Well, if instead of giving money to Junior and having Junior trade, which PS, she's not allowed to do in any event being a minor, you instead have a family trust that owns assets. That family trust can be fully controlled by an adult party at their absolute discretion, and the benefits of that accrue to Junior. And in that way, any benefit that is accrued to Junior in that time, I mean, putting aside some technicalities of the Income Tax Act, which may claw some back, and some relevant minor or affiliated conditions, which I'm not going to go into here, Junior gets the benefit. And because Junior has no other income, if Junior makes $10,000 a year through the family trust money, and if it's dividended out to Junior at, say, when they're 19 years old or something, and they get $10,000 from this, it's way better that $10,000 go to Junior than it does to their parents, who are likely in the top tax bracket and therefore pay a higher amount on the money that has been invested. And what it means is that you can invest, sell, or otherwise use assets entirely at your discretion, and it goes for the benefit of your little pooper. Simple. It's actually quite elegant and makes a lot of sense. So let's talk about how one tax plans through a trust. So I went into this in a bit of detail with Junior, but I want to really kind of delve into some of the numbers so that it is clear and transparent. This presentation that I gave was last in 2018, and I haven't upgraded the marginal tax rates, though they haven't changed very much. So the 2018 marginal tax rates stipulate that, I don't have dividends here, but let's just assume that the capital gain is on the sale of real estate, and the trust has held real estate. That is to say, you know how you normally have your name or a corporation? Well, in this instance, you're going to put down the trust name on title, which you're allowed to do. It's an entity. You're absolutely allowed to do it. So if let's say Mark Morris. Let's say Mark Morris was in the top income bracket. Why pick on me? I'm the person speaking. No, I'm going to pick on Tracy today. If Tracy was in the top income bracket, sorry, Tracy. If Tracy was in the top income bracket, then every single dollar that she takes in as capital gains is 26.76% taxed. That is to say, if she purchased a property for $500,000 and sold it for $600,000, if there was no realtor involved or other costs, she's made a profit of $100,000. That $100,000 is taxed at this capital gains rate, 26.76%. But if Tracy, instead of buying it in her own name, bought it in the name of her family trust, and if the family trust was set up for her little pooper, then when she makes the $100,000, she needs to pay 10.3% on the first $42,000, 12% on the next $4,000, 14% on the next portion of money, 15% here, 16%, 18%, and the highest rate of tax she would end up paying on a graduated basis is 20%, but if you total the whole amount up, she'd probably have a tax rate of something approaching about 15 or 16%, which is very different than Tracy's 26.76% going to the government, all because she set up as a trust from the outset. Note, you can't switch it to a trust halfway through. This has to, you can, but there's tax consequences. This is something that you would be buying the property as a trust in the first place. And for the record, people do this. I actually acquire my properties in a trust. Now, don't get me wrong, banks freak the F out. They have never seen this. Other lawyers haven't seen this. You know, like it's a mess. And you have to really do things in advance and make sure that the banks understand what's going on, and they're going to want the constituent trust documents, and they're going to want guarantor signatures. And it is hard particularly when you're going with financing, but it is legal. It is perfectly acceptable, and it does reduce your tax long term. And this doesn't only involve, by the way, real estate. You can have any number of assets that fundamentally are paid for by the trust. That are fundamentally held by the trust. Shares, your car, any asset, doesn't matter. Real estate is simply an asset, and it's no different than anything else. So we understand now that in this instance, a trust is a really effective way, particularly a family trust, of apportioning value, particularly to people in your family who do not have income that is similar to yours. Where you see this structurally is often in wealthy families, only one partner works. Lucky ducks, but that happens. And the other partner is someone who therefore has available place within the tax scheme to lower their taxes. And so even if there is no junior or little pooper, doing this with the spouse and allocating money that comes into a corporation first to your spouse and then to you can equally serve to minimize taxes, if that makes some sense. And as a result, if you have a high-performing, as an example, commercial property held by a trust, well, you are in fact able to dividend and allocate or spread money in a tax advantageous way for up to 21 years. A trust can only be for 21 years. And if you're wondering why it can only be for 21 years, it's because somewhere along the line, lawyers got really bored, really drunk, and made up a bunch of esoteric rules that no one really understands, and first-year law students want to shoot themselves in the head every time they learn. And who really cares? Just know that it only works for 21 years. Okay. By the way, Chilla, it's a nice picture of you. Welcome to the group. All right. So hold on a second. And Tracy is saying, is capital gains not charged on 50% of the profit? Indeed it is, Tracy. When I say 26.76%, what we're saying is the effective rate of tax. So what you would do is if you have made $100,000 and you take 50% of that, $50,000, and then apply a tax rate of 53.53%, what you are going to get is an effective tax rate of 26.76%. So the effective tax rates that I have here are already counting on you having reduced this in half and therefore taking the appropriate level of tax to the whole profit. Whereas income, you'll note, is double the 26.76 because we never divided it in half in the first place. Does that make sense? That's the reason this chart works the way it does. Does that make sense? I'll just wait till you type a response. Yes, okay, good. Glad to hear. Okay, so are we clear on why it is people will, I'm gonna pause for a second. Does anyone here have any questions as to why people may use a trust, how it is used, and the advantages of doing so presently? There's other advantages, by the way, that go beyond tax, right? You have control over assets. It may very well be that someone has some maturing to do. This isn't a comment on, I guess this is a comment on people generally. We all mature at different times. Some of us at the age of 18 are adults. Some of us are 18. And it may be that you want Junior to go through a couple of years of hardship before such time as they have active control over assets, because if they get active control of assets, Molson Canadian stock will go up and very little else. So there are other reasons to actually use a trust, which consist of control, but I'm talking about the tax planning advantages. Who else has a question about trusts before I get to asset freezes? Nope, none? Come on, Dina, I can see that you're itching here. No? All right, moving on. Let's do this. So now we're going to deal with asset freezes. This is actually much more interesting for me because very few people realize that you can do this, but you can. And an asset freeze is done largely, it can be done for real estate. It's not often done for real estate. But I've seen it done for real estate. And certainly if you have large real estate holdings, oh, it's absolutely done. But I'm talking about for condos and houses and simple multi-res, it's not usually done, but it could be. You will be approached at some point in your career with the following question. Can I transfer my property from myself to my children to avoid capital gains, to avoid probate, to avoid a whole bunch of other taxes that happen on death? And before I go into this, let me back up and explain what happens on death, because not all of us are equally familiar with tax. When you die, there is a deemed disposition of your assets. A couple of things happen with deemed disposition. So deemed disposition of all your assets is as if you have sold all your assets when you leave Canada for tax purposes or when you die. That is to say, I guess I've said this, but I'll say it one more time. It is as if you have sold all of your assets and you must pay the taxes on that sale. Now, practically, there is a provision. It used to be called Section 69.1 of the Income Tax Act. It's changed to a different provision now. But somewhere around 69.1. There is a provision of the Income Tax Act that says that when property transfers to a spouse, even on death, there is no tax. So if you are a married spouse and you transfer upon death all of your assets to that married spouse, you do not need to pay your capital gains. You do need to pay probate, which is a minor amount. It would be up to 1.5% of your assets, but that's not the big tax. The big tax is the capital gains or the recaptures or anything else that go along with it. And so long as you're transferring to your married spouse, no tax. But the moment the last of the spouses, and that's why, by the way, when you go to a lawyer and they're creating a will, they will always say it's advantageous for you to be leaving everything to your spouse before your children. Some people say, can I leave everything to my children? You say, you really don't want to do that. You can, you absolutely can, it's legal. But if you leave everything to your children upon your death, there will be a capital gain, whereas it's exempt from capital gains if it's going to your spouse. So why don't we leave everything to your spouse? And then your spouse can leave everything to your children, thereby deferring the capital gains hit that you will take. Fine, that makes sense. But if you are the last of the spouses, or if you're both in your 90s and frail and you realize that you're both going to go because you both have whatever it may be, there comes a time when this is a realization and you understand there's only a couple of years left. You eventually turn to a lawyer and say, okay, I'm on my last legs. Can I transfer my assets to my children now to avoid capital gains? And the answer to that is no. Because if you transfer, either by adding someone as a joint tenant such that when you die it all fully transfers to them, or by selling the whole amount or anything else, it is a deemed disposition to someone who isn't your spouse. And even if you transfer for $0, even if you don't transfer for any money, there will be an imputed market value to the properties that you are transferring. The CRA is very good at making up their own numbers as to what it is, and you will be hit with that capital gain. And so, a lot of people are stuck holding an asset and not being able to get rid of that asset, because if they get rid of that asset, then they will accrue capital gains for many years. And yet, what happens if you're someone who's held onto an asset for 20 years and something substantive is about to happen to that asset? So let me give you an example. I know someone who owned a small portion of land that was near where the subways were going in Vaughan. And for many years, the property value went up. It went up by the normal, 5 to 8%, whatever it was. And then they did a study, and they started studying whether or not the subway was going to be directly adjacent to this person's land. And this person said, oh my God, yes, I've accrued 5 or 6% gains on this piece of land for many years. But this land is about to treble or quadruple or 10 times in value. It's about to go up massively. Is there a way that I can, and I'm old, is there a way that I can transfer this to my kids now, take on the capital gains tax now at today's value, such that my kids get the value increase and don't have to pay capital gains on this land until they die? Not only is the answer to that yes, it's very simple, you can just sell the land, but there's a better way to do it. You don't need to pay capital gains now, not at all. And you can transfer the future increased value to your kids through an asset freeze. Okay, so we understand the idea. The idea of an asset freeze is to take an existing asset held by someone, crystallize their existing value such that it no longer goes up in value but stays plateaued, so that no tax is actually payable because it is crystallized. And the accretion in value, in additional value, like what would have happened to that piece of land by the subway, will accrue and benefit another party. How do you do it? Well, let's go through it. So, oh, look, I've summarized it. An asset freeze allows people to take a moment in time and freeze their adjusted cost base, that is to say, the amount that they'd have to pay on their capital gains, such that when an asset is sold, capital gains is paid by the original holder of the asset only until the time of the asset freeze, and capital gains are paid by the beneficiaries of the asset freeze from the time of the asset freeze until the time of sale. What did I just say? Can I please chart that? The answer is, of course, I am awesome. Come join me on the following slide. By the way, I know you're all muted, but you're all laughing riotously, undoubtedly, at the jokes that I've put into this slide. All right, let's go on and let's explain. So let's go before an asset freeze. Okay, we are going to assume that we're dealing with a company. Could be a piece of land. I'm saying company, could be a piece of land. This is how it translates to you, but you should know that this exists. Let's say that we have an asset that is worth $1 million. It's a corporation that owns it and owns it as shares. Okay, so the parent owns 100% of common shares that are worth $1 million. That's what it is in day one. The parent owns that corporation and has only common Class A shares. Just a privately held corporation, they own 100% shares. That parent decides to engage in an asset freeze because their value of their land, or the value of the corporation that holds the land, is going to go up massively in the coming years. And they don't want to have that value accrue to them. They're old, they will die, they will have to pay tax. They want it to accrue to their kids. And so what they do is they go to a lawyer, and the lawyer produces an asset freeze, which swaps the common class shares for preference shares that are worth the same amount of money. Let me back up. Common shares traditionally partake in the growth of the company, the equity. Preference shares partake in dividends or other benefits to the company, but not the growth. So what they've done is they've said, we're taking these shares that are worth $1 million, and you are exchanging them for another class of shares within the corporation, preference shares, equally worth $1 million. So you've had no sale. You haven't benefited. The CRA is not out any money. The corporation has said, what you have is $1 million. I'm replacing it with $1 million. There's no benefit right now at all. The only difference is that the shares you now own no longer go up in value. They are preference shares. They control the corporation, to be sure. You will have absolute control through these preference shares, but they will not in any way partake in the growth. Instead, the corporation will then issue new classes of common shares to child 1, to child 2, and to child 3. And let's say that they will issue, let's say 30 shares each, a total of 90 shares to child 1, 30 shares to child 2, 30 shares to child 3. What is the value of the shares on day one that they are issued? Well, The value of the corporation was $1 million. That was contained in the parent shares. They swapped them for $1 million worth of preference shares, and the corporation value was only $1 million. Therefore, the value of the shares being given to the children in day one is 0. So there's no tax consequence. Now, let's go into this. 10 years later, the subway has come in. The value of the land is massively increased. The corporation that holds this is therefore now worth $10 million, not $1 million, because its sole asset, the land holding, is now worth $10 million. What is the state of affairs? Well, the state of affairs is that the parents continue to own preference shares of $1 million. And those shares have not gone up in value because all of the accretion value have taken place. They still control it. The preference shares are controlling the corporation, so they can still do whatever they need to do. But the value increase in the shares have all been to the newly issued common shares pursuant to the asset freeze's dictates. And as a result, when parent dies at this point in year 10 and their shares are liquidated, what is the value of the parent's shares? It's still $1 million. And thus, assuming that they bought the land for $100,000, they now have to pay capital gains not on $9,900,000, which is the value of the company, but rather they have to pay capital gains on only $900,000 because $900,000 worth of benefit has accrued to people who have not died. Child 1, child 2, and child 3. And so if you back up and think about what it is I'm saying, an asset freeze is a way of saying we are able to tax plan from today with existing assets. A family trust is something that you're establishing to account for the basic long-term viability and hold structure for an asset. An asset freeze is when you say, hey, I need to restructure things because I see potential and growth, and I need to put that potential and growth into someone other than myself. That is what is going on with an asset freeze. And you can see how it is you can plan. You're not allowed to avoid tax in Canada, but you are allowed to plan to minimize taxes in Canada. And in this instance, you can see how you're able to do it. Any long-term asset that has growth potential, significant growth potential, can in fact be deferred to either low income potential in individuals or alternatively, if there's massive growth, to people who don't need to sell upon death, which is what would happen in the event that someone is old and holding on to valuable assets. And that is the asset freeze. So, that is what I would say. Oh, I shouldn't say none. I actually have one. I have one. But if you use the facts, you should be ashamed of yourself. I'm ashamed that you are even reading this line. Well, of course you're reading this line because I'm busy amending it in the middle of a presentation and calling attention to it. But there it is. All right. So guys, what questions do you have for me? I know this has been a complicated thing. This is stuff you don't normally deal with, but you can directly see how this is related to real estate. It's pertaining to how corporations can hold real estate, and being able to be conversant, or at least understanding that this stuff exists, means that you can have tangible discussions with your clients and say, you know, I don't know much about this, but I know that asset freezes exist. I know that family trusts exist. And maybe we should just get you in touch with someone who specializes in these areas. And what this is doing for you is it's allowing you to flag these issues. Under no circumstances do you give tax advice. Under no circumstances do you give any of this advice. But knowing that these exist and knowing that there are professionals who can give this advice and structure and do this work, and there are many people who can do that, that is a really powerful thing, and it can significantly help your clients. Is there any disadvantage for an asset freeze? Yes, quite a few, including costs associated with things, and complexity. And there's a whole range of other from a tax perspective, not much, but from a corporate perspective and everything else, unless you have an asset that's going to sorry, the question that Dina asked is, sorry, the question that Cello asked is there any disadvantage for an asset freeze? The answer is, it is incredibly complex and requires a level of planning that really means that the asset has to be going up a lot in value before you actually engage in this project. But you would have to speak to a requisite professional about your particular situation in order to determine the pluses or minuses. There are sometimes some disadvantages, but it's not, most of the advantages are so transparent that they outweigh the disadvantages, and many people engage in them. Dina asked, can you hold family trust assets in a trust and also structure an asset freeze? You absolutely can. The two things are congruent, but you wouldn't want to do that with a properly held trust, because a properly held family trust is usually entirely discretionary, which means that you are able to allocate post facto, how it is you want it allocated. So when the profits come in that year, you can determine which of your family members, so long as they are named, gets what. And as a result, you really shouldn't be engaging in an asset freeze if you've properly structured your trust to be something which allocates control on a discretionary basis. Can you apply this asset freeze if you're permanent residents, if you want to leave it to your child eventually? You would not want to apply an asset freeze to a permanent residence, because in the first instance, if it's a permanent residence, you're not going to pay any tax at all. So there's no reason that you would want to transfer any value whatsoever outside of your personal control, because it's going to be a fully tax-free event. So why in the world would you want to bring anyone in who actually has tax obligations prior to your death? Better that you die, claim your principal residence, and not have to pay capital gains on that in the first instance. Any other questions, guys? That was a lot of questions, but thank you for that. Okay, so look, guys, I appreciate everyone coming. I appreciate, oh, Dina has a question. Hold on, I'm gonna wait for Dina to finish this one. Did this all make sense to you guys? You're welcome to just unmute your microphone, by the way, because people can't see what you're typing. They can only really hear questions, which is better for everyone listening to this afterwards.
Okay, then I am going to ask the question via voice. So my question is that, okay, so if a couple own their family residence, it's their principal residence, and can you hear me?
I can, perfectly.
Okay, perfect. Okay, so and they are trying to structure, trying to do estate planning, and so in that, would it be advantageous? And I think this is the same question that Tracy was typing. That would it be advantageous to create a trust and put that asset in a trust so that it seamlessly passes to the children without it having go through a will and probate and all that?
It would not. So first of all, probate is not a big deal. Okay, probate is just not a big deal. Probate is 1.5%. It's like a $10,000, $15,000 hit for most people. It's not a big deal. The idea is that you can control through a simple will how your asset is to go. And if you just put down it's to go to X, that will be abided by the courts. It will go to who you want it to go to. The reason you would use a family trust is to avoid the tax hit of that decision. But there is no tax hit to the decision if what you're dealing with is a principal residence. As a principal residence, you are not going to pay, on death, you are not going to pay any capital gains because it was your principal residence. And as a result, if your sole goal is making sure that it ends up in the right hands, all you really need is a will, which will cost you $500 to do, allocating who gets what asset. And there is no larger tax consequence. No, the family trust is much more advantageous when used for things that will attract capital gains. So a non-principal residence, but more importantly, significant property, like commercial enterprises, malls, whatever it may be. All of those things could accrue a family trust for these reasons.
So just to further elaborate on that question, I guess I didn't exactly mean the cost of probate. I meant more the taxes that are payable, or the taxes that the children have to pay to be able to inherit assets.
So the children don't have to pay any taxes to inherit an asset. To inherit an asset, the only tax that needs to be paid is by the estate on the sale. There is no tax, and there's only two taxes that have to be paid. Well, there's several taxes that have to be paid, but the big ones are capital gains and recapture, and probate. But probate, which everyone makes a huge deal about, is not a big deal. Nor do you really care to, outside if you're going to die very quickly, or you know that you're going to die in the next month or two, structuring your affairs around a probate tax usually pales in comparison to the benefit that you have by keeping property in its current incarnation if you are able to avoid capital gains. As a way to think about this, if your property is going up by 5% per year, thus you are having value increases of, say, I don't know, $75,000 per year in the GTI on your property. Capital gains on $75,000, if you hold on to it for a single, so if you were to sit there and plan on day one and you're going to live another full year, and you plan and you transfer this to your kids because you want to avoid probate fee of $15,000, you're going to find that by transferring it to your kids now, you have lost a value of 1 year's worth of capital gains free increase in the property itself, which is $75,000. And 26% of that needs to be included as part of your tax, which will come very close to outweighing the 15,000. By year two, it massively outweighs it. And so a good lawyer will actually tell you that unless you're ready to die tomorrow or very, very shortly, the last of you or your spouse, you have to weigh the probate fee, which by the way is 0.5% for the first 50,000, and then it goes up to 1.5% over of your assets, as against and by the way, may not be leviable if you've owned your property for a long period of time, say dating back to before the 70s and everything else, as against the capital gain benefit that you have just by holding on to property that's massively appreciating in this country. So, you know, that's the discussion that has to be had, and that discussion should take place really with the requisite professional who can delve into the individual instance. That's why people hire big guns. Does that make sense?
It does. So what you're saying is that if the title is transferred to the children's names, then in that situation it will be deemed a sale, and capital gains tax will be imposed. But why? If it's still my primary residence,
capital gains tax won't be imposed. But if but from that time that it is transferred over to the kids, capital gains will start accruing, so that when they sell. Because that's not their principal residence. Mom and dad are still living there.
What if they move in? What if they're not moving out?
Okay, well, no. In that case, that's fine. But we're not really talking about that instance. That happens very frequently. We're talking about an instance where mom and dad have chosen to sell to their kids to avoid probate. And in doing so, what they've done is they have put a capital gains hit on their children. Because when the children sell, what they've done, mom and dad, if they own it for that given year before they die, it's capital gains free. If they transfer it to the kids and then the kids sell when mom and dad die, they now have a year worth of capital gains that they have to pay.
Got it. But if the kids are like adults, but still young adults, and you know their primary residence is still your residence, and if you're planning on dying soon, then it's different.
Most people who are living together as a family unit like that, they're not doing tax planning in any significant way. That's not something that happens very often. What's more, if the kids are young like that, there are other worries, including the fact that people don't always make the right choices in relationships. There are marital home issues. There are who's Junior going to be when he grows up? You know, like I'm losing out on my first time home buyer's exemption. You know, I could go into a million things, but everything needs to be put in the mix, and you have to actually have someone who looks globally at the assets and says, okay, here's the advantages and disadvantages to a dollar. Let's try to figure this out.
And do you recommend that we talk to a financial planner for this, or a lawyer?
A financial planner can absolutely do it, for sure. The financial planner should not be structuring a trust or an asset freeze. That would be done by a lawyer. But a tax lawyer, or alternatively an estate planner, a financial advisor, all these people will know these terms. The goal is to you. I mean, I'm not a professional in this area. I'm here basically telling you that these things exist. I'm just highlighting how they work. I'm not suggesting that anyone engage in this. You need the assistance of people who do this professionally, as I do real estate every day, to tell you that this is something that is worthwhile for your circumstance. But yes, the starting point would be a financial advisor. And now you know what questions to ask. Hey, tell me about family trusts. Hey, tell me about asset freezes. Are they appropriate here? And then if they say, I've never heard of these things, get a new financial advisor. If they say no or yes, then they'll tell you why. And that's a good conversation to have that you can now engage in now that you understand that these things exist.
Makes sense. Can you recommend anybody? Can you DM any recommendations?
I can always recommend people, but I prefer not to on this forum. If you want to email me what you're looking for, I'd be happy to tell you people who I've seen do this successfully in the past. That person, again, to be clear, is not me. I'm not an expert in this area. I'm just telling you what happens by people who practice in this area. I've never created a trust. I've never done an asset. I mean, I've had them created for me, but I've never done this myself. I am informing you only of what is done in this area. You need to speak to a requisite professional before you engage in these projects.
Sounds good. Thank you so much.
No problem. Any other question, guys? Nope. All right. Well, as always, thank you all so much for doing this and for being here and being a vibrant part of our community. I'm actually particularly impressed that you guys came out to this one. This is a really hard one. This is a difficult one to understand, but I'm glad that you guys are up for the challenge. And anyone who's been watching this over the course of, I guess, a subsequent replay, good on you as well for taking this on. This is probably as hard or as advanced a topic as we'll delve into in this forum, but it is a worthwhile one to know. Thank you all and have a great day.